I'm Andrew Thornton.
I'm gonna have you come up
Okay.
once we get going. Very good. All right, I'd like to call the December Maumelle Civil Service Commission meeting to order. I don't think we're gonna have any public comments out there tonight. I do want to start off by recognizing our city attorney, who this will be her last go around with us. She is moving on to, I hope, bigger and better things. And every time we have a new city attorney, there's a learning curve. It doesn't matter who they are, and it takes a while to get there, but you had gotten there. So I hate to see you leave, and I wish you nothing but the best. If anything you'd like to say to the commission on your way out?
Well, I would like to say thank you. You guys have all been a pleasure. You guys have all been a pleasure to work with. Even though, I think we did the first appeal that we've had in a long time, but you all did a great job at that, and I know you will going into this next year, which it looks like could be a little bit busier. I just appreciate your service to the city. I know it is a time commitment every single month, and I appreciate you guys for the serious consideration you give to everything and for always working in the best interests of our first responders.
All right. Thank you very much. Best of luck to you.
Call Michelle.
No one will miss her more than I will.
Just going on record.
Next, I would like to thank Captain Ivy, who has stood in for Chief Pickard in his absence. He told me that Chief Pickard is back in town, and the first thing that Captain Ivy told him was he's taking a vacation.
He said not quite yet. He told me another week.
Another week. Well, thank you for standing in. I know it was not completely uneventful.
No, I appreciate it. Thank you.
We also have tonight with us our new city attorney, Andrew Thornton. I visited with him at the last city council meeting. He will be taking over, I assume, January 1. Is that correct?
January the 1st, yes, sir.
Yes, sir. Just wanted to let you come up and introduce yourself, and if you want to say a few words,
Yeah.
feel free.
I'm Andrew Thornton. I've been at the Public Defender's Office the last 6 years. One of those years, I was opposite City Attorney Krebs in the Maumelle District Court, but since then, I've just been in the Pulaski County Circuit Court. I look forward to working with all of you.
All right. We'll see you on the 11th.
Thanks.
All right. Our next order of business is approval of the November 14, 2022 meeting minutes. You should have a copy of that. And when you are ready, I will entertain a motion.
I'll move approval.
Have a motion to approve. Do I hear a second?
Second.
Any discussion? All in favor say yes.
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 All opposed, no. Yes. Motion carries. Didn't mean to vote no on that. All right, it seems like we have an update on the fire department eligibility test.
I'll defer to Chief Buford.
Good evening. Bo Buford, 2000 Murphy Drive. We had 7 candidates come out for the physical agility test, and all 7 candidates passed the physical agility test. We had one person that, could not make it because of a death in their family. So we have been looking to try to do a makeup day for that person, and the Arkansas weather has not been very kind to that fact. We had a couple days we had in mind, and it's just rained nonstop. So we are going to attempt to maybe do a makeup on Friday, if possible. Normally, you probably wouldn't consider a makeup, but we only have the 7. Depending on how the budget goes, we could possibly exhaust all 7 if they all are qualified. So we want to try to use everybody that we can if they're qualified, fully qualified. So that's kind of where we sit right now.
You have that many openings right now?
Right now we have 2. Well, we have 1, and we'll have another one, a resignation that'll be effective. Well, actually, it is effective the 10th. So we'll have 2 openings right now, and then potentially more if the city council blesses us with some new positions. Yes, sir. Hopefully.
Does that look good?
Right now.
Knock on wood?
Yes, sir.
We'll knock on wood for you.
Yes, sir. Yes, sir. Thank you.
All right, well, I'm glad you got some qualified candidates. That's a start. All right, on her way out the door, I have asked Madam City Attorney to review for us the manner of conducting appeal hearings. She's done this for us before. It's not something we do often enough to remember very well. That's particularly true in my case, so I figured a review would be very helpful.
I'm gonna switch spots so y'all can see my PowerPoint.
Well, I wondered what all that hubbub was about.
Yeah.
Now I know.
There it is, it's on the big screen, there we go. All right, well, this is gonna be strikingly familiar to the last time I did this. I've made just a few changes. I do hate that our two candidates for the commission did not attend with us tonight, but
Right.
perhaps they can watch it on recording. This is just an overview of sort of the procedures that we go through each time we have an appeal, along with just general rules for the Civil Service Commission, kind of an overview. And it really is more aimed at new members, so sorry if it's a little bit repetitive. I'll go over the parts that I feel like y'all know pretty well already.
We did, trust me.
So the civil service rules are created by statute in Arkansas, and there are particular sections dealing with the size of your city. So the statute cited here is one of the key ones that talks about the formation of a civil service commission. We have to have a quorum to operate, so we have to have a majority of all the members that are on the commission in order to be able to do business. We have to use certain rules of order. So there are certain rules that we've adopted as our Civil Service Commission rules, and we recently revised those. We always are going to follow those. And then we're going to use Robert's Rules of Order for the general way we conduct our meetings if in doubt. And we don't always do those precisely as they are written in the Robert's Rules book, but our code has some slight modifications, our city code does. But basically, that's what we're going to do. The commission is going to approve testing dates and rules for promotions and hiring and all those types of things, testing for our positions. But one of the key functions of the commission is to hear appeals hearings from disciplinary decisions. So that's more what we're going to focus on today. We do, as we just mentioned, we the commission certifies eligibility lists and testing conditions and rules related to that. But today we're going to move on and talk about disciplinary actions. So anytime someone receives a suspension, a reduction in rank, a demotion, a reduction in their rate of compensation, or a termination, that's when they have the right to appeal it to the Civil Service Commission. If, Captain Ivy just gives them a little verbal warning because they didn't make a good decision that day or whatever, they don't get to appeal that even though they may not agree with it. So not everything goes to the commission, but more serious disciplinary decisions do go to the commission for appeal. So it begins by the employee receiving the process. There is a certain process that either police or fire have to go through in order to do investigations of disciplinary circumstances and to provide written notice to the employee of the policies that they have violated or allegedly have violated and the discipline that they are going to receive as a result of those policy violations. So as they have their own after they have their own internal process and hearing regarding those things, then they are going to be notified of the final decision. And then the employee has 10 days to notify the commission if they want an appeal. And they can do that by emailing Chairman Harrington or Doreen and for the commission and letting them know that they do want an appeals hearing. Once they do that, we have 15 days to set the date for their hearing, and that we do that by a scheduling order that you guys have all seen when we just did one that sets out when are your stipulations going to be due and all, other pleadings, motions that they want to issue and have the commission issue for them. If they don't make that decision within 10 days, then it becomes final. All right, so the role of the city attorney's office at that stage is to act as the commission's attorney, right? Because at that point, the commission is the city's sort of last line of defense, and the city attorney always is going to represent the city. So it is the commission's job to kind of be that last double check of, hey, did we make the right decision? Was the discipline appropriate for the particular types of violations that occurred here? And to be that good, objective, third-party set of eyes to protect the city in case there might be other lawsuits or appeals in circuit court going forward. So at this stage, the city attorney represents the commission. Of course, the commission could decide for whatever reason that they want different counsel, and then the commission has the right to hire that counsel. I'm not sure where the money comes from if you decide to do that, but by statute, you can do that. It's a little different in that for this part, we have outside counsel come in and represent the police department or the fire department. So we do a request for qualifications periodically that I've sent out to advertise for law firms to send me their qualifications, and we've selected someone to serve as our counsel for that purpose. So they come in and they do all the witness preparation and all those things and get ready for the hearing. Once it goes to an appeal to the circuit court, then it comes back to the city attorney's office and they take over, because at that point it is the city's decision. You guys have ratified it as the city's decision, and the city attorney represents the city. So both sides, of course, have a right to have adequate notice of the hearing and to be able to subpoena witnesses. So we have those forms that we send out to subpoena managers who have participated in the decision, other officers who may have observed bases for the finding of the policy violation. All those people get a subpoena to attend, and it can add up to a pretty lengthy list of folks. So once we get to the hearing, the chairman of the Civil Service Commission presides at the trial and determines and decides questions about pleadings and the admissibility of evidence. So Chairman Harrington essentially sits as it's what we typically think of in the judge role. You guys all together, including him, sit as a kind of a jury role at the same time. So it's a little different than other judicial proceedings, but that's how it flows. So the city has the burden of proving by preponderance of the evidence that the employee committed the violations of policy that for which they were disciplined, and that the discipline they gave out was appropriate. And they go first. The city goes first in giving their opening statement, presenting their witnesses, and then later on in giving their closing. Opening statements are given by both sides. Nothing in those opening statements is evidence. But usually they're painting a picture of what they expect to see in the hearing and giving you kind of a preview of what to be looking for and starting to state their case of why their side should win. But again, it's not evidence. Now, joint stipulations of fact are evidence. So before we get started on an appeals hearing, we require that the parties get together and say, what can we agree on? What can we agree did happen? And then based on those decisions, they get together and they present joint stipulations of fact. And that is, we agree that this is true, that this happened, and nobody has to prove it.
We will get a copy of that, correct?
Correct.
Ahead of
So,
time.
right, yeah, you'll have that ahead of time. You can take those with you into executive session when you get ready to make your decision. They are very important. You read them before, during, after, and it cuts down a lot on the hearing time, because once it's established by stipulation, we don't have to call 10 witnesses to prove it, which is always nice if we can get the parties to work together well in that way. All right, so the rule is that if either party wishes to exclude the witnesses of the other party from the hearing room, they can do that, and it typically is invoked. I had a small trial relating to some dogs last week and did not invoke the rule, and everybody, the judge kind of looked at me like she couldn't believe I didn't do it, but It was just one of those situations where I wanted the people to get to see the whole proceeding because they had never really done that before. And I didn't care if the witnesses on the other side stayed in there or not, because I knew they had their story already. They both lived together. So that, that may be unusual, but occasionally it can be that witnesses are allowed. But for the most part, witnesses are always going to be back in another room, not hearing what the other witnesses say, with the basis being that they're not going to alter their testimony based on what they've heard somebody else say because they don't know.
It seems to me the last time we did this, since the fire chief in that particular case was front and center on this suit, that he was allowed to stay. Is that
Correct. Yeah, so like the chief or the person who is acting as the chief at that time may be allowed to stay as the party, just like the appellant is going to be allowed to stay as the party representative, the representative of that particular side.
Do both sides have to agree on that? Or?
No, you're
Okay.
entitled to that.
Okay.
Yeah. So the city's lawyer is going to present the city's case first. They are going to call all their witnesses and do their direct examination. And of course, then the appellant's attorney is going to cross-examine those witnesses. And the city can then have an opportunity for rebuttal. So anything that's brought up, just what's brought up in cross-examination, they can then come and redirect and ask them more questions on what they just said with the final round, the last round of what they said. And then, witness testimony is typically over after that. There may be occasionally, very, very rare occasions, there can be recross-examination, but that's not typical. So at the conclusion of the city's case, the city is going to say the city rests. That means I've presented all the evidence that I have, and I believe I've proven my case by preponderance of the evidence. At that point, the employee is going to call their witnesses. They're going to present exhibits. If there are exhibits that are not stipulated to, they can ask for those to be admitted into evidence, and the chair has to make a decision on whether to admit those. Most exhibits are typically going to be stipulated to. Just like last time, we got probably a dozen different documents in our binder that both sides had said we're going to agree to let you look at this, and that these are the documents that were relevant in this case. But, as they go through with witnesses, there may be other exhibits that get presented as well. Then at the conclusion of the employee's case, they rest, the same as the city. Because the city does have the burden of proof, it can call rebuttal witnesses if needed. Occasionally you'll see that, but it's probably not very typical in a commission appeal hearing. So at the end of the employee's case, the chair should ask, are there any rebuttal witnesses, even though it would be pretty unusual for there to be any.
Does the city get to cross?
So if there are rebuttal witnesses, the city will bring those up after the employee rests, and then the employee can cross-examine those witnesses.
So that is the cross?
Yeah.
Okay.
Yeah. And then at the rebuttal, after the rebuttal witnesses, if there are any, the city rests again. Then there are closing arguments, and again, these are not, like opening, they're not evidence, but the parties are going to use that opportunity to summarize what's been said, to point out things that are particularly relevant in their opinion to the decisions that were made, and kind of paint it from their side's perspective. The city goes first, employee's lawyer goes second. Occasionally, then again, there'll be like sort of a rebuttal where the city will respond to what the employee said. So there may be objections to evidence if not everything is stipulated to. And at that point, if the chair agrees with the objection, he will say that he sustains the objection. And in that case, the question shouldn't be answered, or if it's a document, it won't be entered into evidence, and it won't be considered in the decision. If the chair disagrees with the objection, then they overrule it, and then the question can be answered or the document will be admitted. So commission hearings are a little different than a regular trial in that the Arkansas Rules of Evidence don't apply. However, this is a part of due process. We are a political subdivision of the state, so due process does apply to the city. And that requires that we have some basic fairness principles and that we provide, some appropriate safeguards for the evidence be reliable and relevant to the case. So there may be situations where we don't allow things that are either not reliable because they're very clearly hearsay, or they are are just not relevant to the case at all and are prejudicial to one of the parties and doesn't have anything to do with the case. So those decisions will come into play. Sometimes also attorneys try to introduce evidence that other employees committed the same or a comparable policy violation, and were disciplined less severely. Whether to allow that type of evidence is the prerogative of the chair, but it is better to deal with the case at hand as opposed to revisiting disciplinary actions. Rarely are two cases going to be similarly situated in every way, right? Rarely are two employees going to have the exact same employment history, have received the same number of disciplines, have made a decision that's exactly comparable. That's going to be the unusual case. Let's see. So we can look a little bit to what federal courts have said about that sort of similarly situated evidence. So to establish that a similarly situated employee was treated more favorably, you have to have same supervisor, same standards, same conduct, and no mitigating or distinguishing circumstances. And the employee has the burden of demonstrating that both employees were similarly situated in all respects. So typically you don't want to get caught up in that. It's going to be a rare circumstance where that's really relevant. So the preponderance of evidence is the city's burden of proof, which is different than in a criminal case, right? We have to prove things beyond a reasonable doubt. The preponderance of the evidence is different. It's just more likely than not, and that's the standard the city has to go with. So we want to look at the witnesses, we want to look at the evidence, the documents that we have before us, and base our decision only on that. The commission's decision should not be based in any way on sympathy or prejudice, right? It shouldn't be based just on how you feel about a particular person or even about their life circumstances. I mean, there may be things in their life that are hard, but that's not necessarily a reason for a disciplinary decision. Let's see, I think I've covered all that. The Commission's duty is to weigh the evidence presented by both parties and determine whether the city carried its burden, proven by the preponderance of the evidence, that the employee committed the policy violation with which they were charged, and that the punishment was appropriate. And this is just the definition from the model civil jury instructions of what the preponderance of the evidence means, and it's more likely true than not true. Consider all the evidence and decide which evidence is more believable. So it's not necessarily who has more documents on their side or who has more witnesses on their side if one side's witnesses are more believable than others. And then if you decide that the evidence is equally balanced, you can't find that it's been proved. So you do have to look at, if you think it's just a dead tie, then the city has the burden and it goes to the other side. Executive session. So the commission is going to make its decision, it's going to deliberate and make its decision in executive session. Executive session is rare, like for the city council, for the planning commission, for any of those types of bodies. Y'all are all required to do business in public, right? If you're going to talk about city-related business, it has to be in public. You're not supposed to do that in a bar. You're not supposed to do that in somebody's home. It should be open and recorded and all those things. But executive session is permitted for considering employment, appointment, promotion, demotion, discipline, or resignation of any public officer or employee. So it's just going to be you all in the executive session. I don't get to come, right?
You're not gonna be
Attorneys
here
can't
anyway.
come with you. Well, Andrew doesn't get to come. Don't go into the executive session, Andrew. I know you know that. So, but, and you can reach a decision in executive session, but it's not legal unless you vote on it out here. So you have to come back, reconvene, and then present your motion here for how you're gonna decide and vote on it.
And that is a roll call vote, correct?
Correct. It should be a roll call vote. A decision by the commission does require a majority vote of members of the commission, and that's where it can get tricky when you have people who have to recuse, because we have to have at least 3 out of 5, right? And it doesn't matter, even if one's not participating, you still have to have 3 out of 5 to reach a decision. Otherwise, management decision is considered final, and the employee can appeal to circuit court. And we really do want a good, objective commission to make that decision. We don't want that, we don't want to skip that step, right? That's not really in the city's best interest. So that's what we want. The chairman does vote on that. And then in the event that there is a determination that there was a wrongful discharge or a wrongful reduction in rank or compensation, then the employee can be entitled to back pay for what they have missed during the time that they've been out of work. You do take into consideration other money they've made during that time, but you don't do all of that in the first initial hearing. That's a decision that has to be made a little later on. There has to be some calculation if all that comes into play. All right, so the commission does have to make a motion to either uphold the city, overturn the city's decision, or modify it, whichever the commission decides that they want to do. You have to have a second, just like any other motion, and then you call for the vote. Once that's taken, then the party that loses can decide whether or not they want to appeal. Either party can appeal to Pulaski County Circuit Court, and we do see that pretty often. So in the decision, again, you can uphold the city's decision, you can reverse the city's decision, you can modify the city's decision. You can say it was appropriate, they did have policy violations, it was appropriate they received discipline, but we determined that the discipline should be this many days of suspension versus that many days of suspension. As far as ahead of time, ahead of the hearing, ex parte communications. I'm sure many of you have heard of these in a judicial context. It's inappropriate for either party to discuss a case with a judge beforehand. We don't want just one party discussions with a judge. It's the same situation in this case because you are all essentially acting in a judicial function. So if someone does try to discuss a case with you, either the facts of a case or evidence related to a case or just their own thoughts about it, that's not a discussion that you guys should have. We want to be fresh ears and impartial for what we're going to hear when we come into the hearing. We do have, under Section 1983, parties are entitled to due process, and we don't ever want to deny them that due process that they're due as an entity of the state. Recusal can be very important. We know you've seen Greg has recused from the last hearing. Basically, if you have a personal or a business relationship with either side, you should recuse because we don't want any sort of appearance of impropriety or bias. So if any commissioner, and it's not just, you see someone here at meetings occasionally or something like that. It's you visit in each other's homes, you go to meals together, you see each other and socialize regularly. It's obviously not fair to either side if that's the situation, type of relationship that you have. If if that's your best client, again, that's not an appropriate relationship to have. That's an appropriate time to recuse.
Let me add too right now, it doesn't matter whether you think in your heart of hearts that you can be non-prejudicial. If the attorneys of either side have a question in their mind about you, you should recuse.
I agree.
I mean, it doesn't matter what you think. If there is even the appearance of anything like that, you need to recuse. I fully expect at the rate the city council is going, that we're gonna have a repeat of what we had in our last appeal, and I think there's gonna be 4 of us. I doubt there's gonna be 5 at the rate they're going, so it's not like we've not done that before, we've done it, but, hopefully we will not have to have anyone recused, but if there's the slightest doubt in your mind, do it.
We walked over that night, who were talking about what the issue is, and who's the representatives.
Well, you mean who the employee
Yeah.
is? I mean, you can know the name of the employee if you want to, and we've sent out emails, I think, probably when I sent out the scheduling order, it would have their name on it. But as far as details of why the discipline was issued, no, you wouldn't know.
We don't know their attorney's name and that information either,
So you will receive that ahead of time because they will,
no stipulation.
right, when they send out pleadings and all those things, and those come to you. And again, it's not, if you have ever, you could have used that person 15 years ago to do your will, and that wouldn't be an issue. But if you have an ongoing relationship with them, then it would. You know, obviously with Greg, you know, one party's attorney was his business partner,
Yeah.
you know,
Yeah.
so it was
That was pretty
appropriate
clear.
for him to recuse.
So the determination that took place, it went through HR, correct? It probably came across your desk, is that correct?
Yes.
But you're gonna be representing the commission.
I'm not going to be
She's
representing
not gonna be
anyone,
here.
but I
got it.
would be,
The city attorney's not gonna be the city attorney, it's gonna be the
Correct.
commission's attorney.
correct. And it
Isn't that
is
a
an
conflict
interesting
that you're
spot
already
to
aware
be
of?
in.
Isn't it?
So I don't vote, and
Right.
the city attorney doesn't vote. The city attorney's position during these hearings is to advise regarding procedural requirements.
Commission's attorney.
Correct.
That,
The city attorney
just odd.
functioning as the commission's attorney is to advise you regarding the procedure you're to follow. I would never tell you how you should vote, right?
right, and you don't get to go to the executive, even though
Correct.
you're our attorney, you don't get to go.
That's right. That's right.
It's odd.
And those rules apply, FOIA, because of FOIA, you know, your attorney as your attorney never gets to be in an executive session, only if they are like the employee who's, being discussed, would they be in that type of executive session? Or if they're, you know, you could have an attorney that's a city council member simultaneously or something like that, or a commissioner simultaneously, but otherwise you wouldn't have your city attorney, who is your attorney, being there with you. It is unusual.
But it's very valuable to me, because if there is a legal point that I'm unclear on, because I don't do this every day, preside over legal proceedings, to be able to reach over and ask the city attorney, who's now the commission attorney, to clarify something for me.
And it can also be helpful if the chair is having a hard time making a decision over whether to, you know, a piece of evidence should be
Yes.
considered admissible. Those are more the types of decisions your city attorney is gonna help the commission with during the hearing.
And I will instruct attorneys on both sides there may be times where they have to exercise a little patience with me, simply for that reason.
So, should one party want to appeal, they get 30 days to make that decision. And if they decide to appeal, then the commission issues a written order containing its decision. You're going to, at the time you issue your verbal decision, state that the commission finds that they committed this policy violation, did not commit that policy violation, whatever you decide based on the policy violations that are listed. And then that the discipline either was or was not appropriate or should be modified. So the order is primarily going to repeat what the commission said at the conclusion when they came back and made the motion publicly. But there may be some other, you know, technical issues that get addressed. The city attorney, or at least I did, at the last time I prepared, the order and then had the commission approve that order, but it was very closely based on what was said at the conclusion of the hearing. Then we have the transcript prepared. We do have a court reporter that comes and creates that transcript for us at the hearing. All those stipulations and exhibits get included in that transcript so that it can be sent to circuit court. And then the circuit court reviews the commission's decision, generally on the record. They can hear some additional testimony if requested by one side or the other, but they're primarily gonna look at the record that happened, of what happened during the civil service appeal. So it is very important, it's a very important proceeding, and it can have effects even after the hearing itself. Once they get a decision from the circuit court, they have the right to appeal it all the way to the Supreme Court of Arkansas. They just have to follow those rules of procedure for appeals and for, obtaining transcripts and getting all those things sent up to the Supreme Court. All right, I think that's the conclusion. Anybody have any questions? So it was appealed. It was appealed, but it was settled prior to being decided by the circuit court.
Who settled it?
It was settled on terms agreeable to all parties.
Attorney.
Okay.
Yeah. It was approved as any settlement agreement would be approved. The mayor,
So we don't get
approved it as well.
to have a say-so in that?
No.
There are certain,
Once
There's
we make
certain
our ruling,
discretion.
we're done.
Yeah.
We're out of the loop. Now, they can continue, like Madam City Attorney said, they can appeal it to circuit court if they want to. But we've done our part of the gig at that point. Anybody have any questions? Everybody crystal clear?
I have a question, Melissa.
sure.
Take it that stipulations the commissioners have to accept as true,
Correct.
but any other witness who comes, even though they're all under oath, the commissioners get to decide who do they find more believable, just as they would if they were on a jury in a trial.
Correct.
They get to choose, I believe this person's testimony because they're more credible, their explanation of the facts is more believable, that kind of thing.
Yes, they can look for
Judgment itself.
inconsistencies in their testimony. Those become very important. They can look at whether their testimony is corroborated by other testimony, all of those things to determine who's more believable.
So everybody's super ready for January 11th, right? No questions, ready to go. Thank you very much.
All right,
This is the
sure.
hardest thing we do. Anybody that's been through it once knows it. I mean, the rest of it is fairly straightforward, but it gets heavy in a hurry when you have someone's career in your hands, and you literally do. So I want you to, I don't even have to tell you this, but I want you to take it very seriously. All right, any additional comments? If not, I will entertain a motion to adjourn.
I move we adjourn.
Have a motion, do I hear a second?
Second.
Any discussion? All in favor, say yes.
Yes.
Yes, any opposed, no. Motion carries. See you on the 11th, 1 o'clock.